Well, how many of you just want to be happy? What's up, everybody? It is Friday, TGIF, Friday. Listen, we're done with working. Some of us, some of y'all got a little time to go. I know it's probably your lunchtime or something. That's all right. Hold on. Help is on the way. Thank you for joining us into this virtual sanctuary of the St. James Show on this afternoon. Listen, it's still morning here in California. It's only 10:30, so we are still looking at the sunrise, and it's going to be a wonderful day and a not so much of a hot day today. So that's what we're glad about. Will you do me a great big favor, as I always ask you to do? Will you please, if you're not a subscriber of the St. James Show, will you hit that subscribe button, hit the like button, and also turn on all your notifications so you too will know each and every time I come live. It is not February. Listen, I just noticed that. We're in July. What do share it on your social media site. Did nobody tell me nothing? Also, you can become an exclusive member right here on YouTube, clicking the link in the description of this video. Throughout the show, if you'd like to donate, you can donate to the St. James Show at $ the St. James Show through CashApp and also through Zelle, the St. James Show at att.net. Always scrolling at the end, at the bottom of this the window here. And also there's our Patreon link. And we're coming with documents, official court documents today that can always be found on the St. James Show Patreon under the $10 tier. So you can always go over there and check out those court documents with this case. We are in Pittsburgh today, everybody. We were there yesterday and we are back in Pittsburgh today. But we back with evidence. Somebody say evidence. We are back with evidence. We are back with proof. We are back with some explosive testimony from the hearing that Attorney Blackburn had to go to yesterday, wasting the court's time. So the court took a little time and said, come on in, let's waste some of your time today. So that's what they did on yesterday. And we are going to read verbatim as to what Tyrone Blackburn had to say to the court on yesterday, okay? So you got to do me a favor, though. You got to make sure you are hitting that subscribe button, hitting that like button right now, everybody. Do share on all your social media handles, even OnlyFans and Just for Fans and all your fans, okay? Share. All right, and thank you for being a part of the St. James Show. I know it is early. Y'all not used to seeing me this early, but I was going to take a half day off anyway. And then I said, you know what, let me grab these transcripts and let's go through this. What's up, Tashi? What is up? Let's see. All right, Unorganized Chaos Network. Hang out, chill out. You got a lot of questions. Chill out. All right, we'll answer them all. What's up, Sean? Dr. Henry, good to see you. Magnum is in the building. Seta Moore, Erica, good to see you. General Davis. Rita Rue is in the building. Shy Roslyn, good. What's up, Shy Roslyn? Hope you guys are hitting up Shy Roslyn for her beautiful custom-made jewelry. All right, so hit her up. Where's she at? Right there. Jesse says, a marvelous. It's marvelous. It's the Lord's doing. The Lord is doing it. The Lord is doing it just like he said. Who sung that? God is doing it. That was at James Hall. Just like he said. You know how you do. What's up, Jay Rochelle? We are going to get into these transcripts. When I tell you, the mob squad, the alleged extortion squad, the alleged conspiracy squad, the alleged defamation squad have to be a little nervous. They got to be a little nervous. The rubber has met the road. The hens have come home to to roost, and every other cliche that we can use. It's happening in real time here in 2025. It is happening. Oh, my goodness, it's happening. And we're going to be here to report it. If nobody else reports it, Sean, St. James is going to be here to report it. There's some people that are mute. They think nothing's going on around here. Oh, there's a lot going on out of Dallas and Pittsburgh. A whole lot. Ooh, boots on the ground. Y'all think St. James ain't going to show up in Pittsburgh a day or two, or 3 or 4? Move over. Let me sit down. Give me a seat on the bench. Give me a seat on the bench. All right, everybody, let's get right to it. Hit that like button, everybody. Don't leave me out here hanging by myself. Hit the like button, all right? Oh, we are getting into the transcripts. This is, when we say the transcripts, this is verbatim what was said from the judge, which is the court, and from Blackburn, okay, which is the one this hearing was for. Attorney Blackburn, as we know, was the attorney for Dwayne Youngblood, who is being sued by Bishop T.D. Jakes for defamation, a conspiracy, extortion, all of the above. Bishop Jakes is suing Dwayne Youngblood and the co-conspirators. Now, the co-conspirators haven't been named officially yet, but they have put some names in the motions, in the responses, in the things that one of the names that they put down was the podcaster who they finally stopped naming the podcaster and start saying Larry Reed. So that's one of the names that have been swirling around in all these documents. So it's our sneaky suspicion that in not too many days hence, Bishop Jakes may actually put Larry Reed in this lawsuit or create another lawsuit. We don't know. But how it's going, we can talk about a little bit more how it's going after we get these deals read on today. These are the proceedings from yesterday, okay? So let's get into it. Make sure you guys are hitting that goal button and helping us reach our goal in the chat, our super chat goal. And I believe it may be anyone. I'm not sure. I did maybe $5 or anyone. I'm not sure what I did. But just click on it. It'll guide you, O thou great Jehovah. It'll guide you into giving and guide you into supporting the St. James Show. All right. It is Friday. All right. So let us support the proceedings. Here we go. The court. We are here today on the record for the sanctions hearing pursuant to the court's order, docket number 53, issued on June the 26th, 2025. Would counsel please enter their appearance? Counsel for the plaintiff? We have Mr. Janey says for the plaintiff, Thomas Dexter Jakes, the Janey Law Firm by Darrell Janey. Good afternoon, Your Honor. The court says good afternoon. Mr. Janey, and with this court's permission, I'd like to point out that Mr. Jakes is here in the courtroom in the gallery, Your Honor. On yesterday, we didn't have any evidence of it if Bishop Jakes did Bible study on Wednesday night. And was in court on the afternoon on yesterday. Bishop Jakes means business. All you people who called Bishop Jakes dumb for bringing this lawsuit, he showed us on yesterday with even more vigor that he is ready to fight to the end to protect his name, his character, to protect his family, his legacy, and the church from defamation, from extortionists, and from the conspirators. He was in court on yesterday because I told you the judge had said he had to be there if they wanted to bring a petition for fees against Youngblood. Okay, so let's continue. The court. Okay, good afternoon, Mr. Push. Dustin Push on behalf of plaintiff from the law firm Mere Watkins Phillips Push. I'm joined by my colleagues Amy McCann Roller and Casey Christian as well. They were suited and booted in that courtroom. The court, good afternoon. Mr. Chaswick, good afternoon, Your Honor. Devin Chaswick from McNeese, Wallace, and Nurek, also for the plaintiff. The court. Mr. Blackburn, I presume. Tyrone, Tyrone says, yes, Your Honor. The court, okay. So a Rule 11 hearing, especially one that's ordered su sopta by the court, is a somewhat unusual proceeding in that it's one that, whereas the court is normally an umpire between parties, the court by necessity has to take the lead in examining the evidence and creating the record with respect to whether there was a violation of the rule, and if there was a violation of the rule, the appropriate sanction to impose. Remember, everybody, I'm reading the transcripts as they are. Hit the like button, okay? All right. In this case, the court issued its order on June 26, ordering Mr. Blackburn to show cause about why sanctions should not be imposed as a result of his authoring and filing briefs and submissions before this court that contained what the court believed to be, and I believe has been confirmed, at least in part by Mr. Blackburn's subsequent filings, artificial intelligence, hallucinations, which, amongst other things, miscited case law, including this court's own previous filings in the case. I issued that order, and that order required Mr. Blackburn to come to court. The order invited the plaintiff's attorney to come to court only to the extent that they were seeking attorney's fees as part of the proceedings. So, Mr. Blackburn, you are the subject of today's hearing. For the record, sir, are you representing yourself, or do you have counsel with you today? Mr. Blackburn says, I'm here alone. All alone. The court, okay. And then the next question that I have for you is, do you have any witnesses or documentary evidence that you intend to present to the court today? Mr. Blackburn, outside of what I provided on the docket, I don't have anything else, unless I didn't want to give the full search history. It was a lot of cases. I just gave like a small sampling of the cases that I researched for this motion. So if the court wants, I can supplement that with an Excel spreadsheet of the cases and their relevance. I just don't think the court would want that. The court. Are you referring to the document that you've already filed in support of your submission at ECF number 57 and its exhibits? Blackburn says, yes, but there's more than that. I didn't want to inundate you with so much documents. There's more. I actually have additional samples I can show you. My metadata from my devices to show that these were researched on the dates and time that I said that they were researched. So I have sample motions as well as additional case law and additional search history. And he full of it. So just so the court is aware, when I have a lot of cases, and like I said in my papers, that I represent a lot of people for free because, you know, they just can't afford to pay. So on the day I wrote this, I typically go to bed at like 2 o'clock in the morning, and I wake up at 6. The court says, I'm going to stop you right there, just so that procedurally we're all on the same page as to how we'll proceed. The next question I was going to ask is whether there was anything that you would like to testify to today, to supplement or to elucidate any of the written filings you already provided to me. I take it from that what you've already begun to say, that the answer is yes. Am I correct? Mr. Blackburn says, of course. The court will raise your right hand to be sworn. Okay, so you may proceed and offer to the court any additional testimony you would like the record to reflect and for me to consider when determining whether sanctions are appropriate. In addition, when you're complete with your testimony, I intend on asking some questions, not only about anything that might come to my mind during the course of your testimony, but also about some of the submissions you've already given, specifically your declaration at ECF 57-1. Mr. Tyrone, okay. You may proceed, sir. Tyrone says, thank you. So as I was just sharing, typically my days run long because of the amount of work that I have. But for this particular motion, I think the night before I went to bed like 1 or 2 in the morning, and I woke up at 6. And I began doing the research and beginning to outline my motion to dismiss. The court says, but with this particular motion, when you refer to the motion, you're referring to the motion to dismiss that was filed on May 5th? Blackburn, yes, it is, Your Honor. Okay. Blackburn says, so I typically do all my research. I typically outline whatever the motion is or the document, and then I do the research for the case law. And then I put it all together. I try to find matching things that make sense. Oh, he's way over his head. So I never used this Lexis AI thing before. Before I had regular LexisNexis, which required me just, independent use, search terms, and all that stuff. But this thing is completely different than what I am accustomed to. And when I had the ability to upgrade, this is what was sold to me. Not upgrade, but to renew my contract. This is what was pitched to me. I've been a Lexis rep since I was in law school back in 2010 up until now. How you a rep and you don't know how to use it? And I've been using them from then until now. So I didn't think there was any issues with them because of how it was sold to me. But again, not making any excuses. I take full responsibility for not reviewing and really cross-checking what was spit out from the program after I uploaded the case that I thought was relevant. I uploaded the court's opinion, and I also uploaded relevant facts for this, pertaining to this case as well. He's blaming the software. What I should have done was probably just recall the first motion that I had filed and just restructured it. But I didn't do that I don't know why I didn't do that, but I didn't do that because I thought that, I got this new thing, should just use it because it was pitched to me to do. So, that's pretty much it. I just made a mistake, I really don't have any other explanation beyond that. Judge says, so I appreciate that you're taking responsibility for what is acknowledging that the May 5th brief was created by the Lexis AI tool. Mr. Blackburn says, yeah, the protege. Judge says, what's that? He says, well, protege, it's called protege. The court said, protege? Tyrone says, and before I wish I had known this, but before I agreed to upgrade my subscription, I should have done more research on it. I didn't realize it had a lot of issues, and subsequent to having these issues come about, I've done a lot of research, and I've learned that there was a study done by Professor, here he go, Benjamin Perrin, who said that it's riddled with mistakes and should not be used in any form. And then on Reddit, there's a whole bunch of complaints. Lord have mercy. There's an F rating on the Better Business Bureau. So I just didn't know. I should have done my research. I should have done a lot more diligence before accepting this, upgrading, utilizing it in any work that I do. The court asks. He said Reddit. That's what he said. Mhm. The court asks, do you have a paralegal in your... He interrupts and says, I have nothing. I have nothing. I mean, the thing is, Your Honor, a lot of the people that I represent cannot afford to pay. They can't afford to file their own case. So what I do is I do the work for them. And if they get anything back, I just take that from my out-of-pocket expenses, such as attorney's fees, not fees, but course costs, the expense for depositions, and even experts. And I take that back. And then I let them keep whatever they have, because a lot of them are disabled because of medical malpractice issues, or they have issues regarding loss of their employment because of age or disability. So there's a lot of different things that these individuals suffer from. No, the judge says, I appreciate that. And in this court, we have a number of lawyers that represent public interest or pro bono cases. But the problem in this case is that Rule 11 is a non-delegatable duty. Tyrone says, of course. The judge says, I asked if you had interns or secretaries because, of example, if you had an intern and you gave the intern the stack of the facts and the brief, and you said to the intern, draft a brief for me, and then you filed a brief under your signature. Tyrone says, still my responsibility. Judge says, it's still your responsibility. And it doesn't make a difference if it's a product sold by a computer company that says that they can write your briefs for you or not. It's Mr. Blackburn and Mr. Blackburn alone who is representing to this court that the representations are accurate and are truthful. And I guess some of the questions I have, and I'm going to move in my questions from your declaration before the court. In that paragraph 3, for example, of your declaration, you state that you received a safe harbor letter from plaintiff's counsel, which you attached as an exhibit to your declaration on June 17, 2025. And that you immediately then began reviewing and revising the memorandum of law. And the question, are you referring to the May 5th memorandum of law? Tyrone says, yes, but Your Honor, before that, I had already highlighted in my reply that, I acknowledge that I acknowledge the errors. And in my affidavit, I may have outlined what was supposed to be correct citations. So that's what I was referring to. But when I got the letter, I had spoken with my client, my former client, and I explained to him what it was. And I explained to him that I had a duty to make the corrections and to correct the record, and that I was in the process of doing that. Y'all hit the like button for me. Judge says, and this was after the June 17th letter? Tyrone says, yes. But before that, during the motion period, I had already highlighted everything that I needed to make corrected. And I was very slow at actually making them and uploading them. And then I got this June 17th letter, and I just put my focus on that. And just to explain what was happening, because I think context is important. I have about 7 clients who filed suit against Sean Combs. And several of them were witnesses in the criminal case in the Southern District of New York. Now, trying to explain why he didn't do his work. He was over there clout chasing in New York at the Diddy trial. I digress. So a lot of my time was spent there with the prosecutors, prepping them and preparing them to testify. So this kind of what delayed me in having the time to immediately submit. Jake's team, I think he's lying here. Thank you so much, Nicole, for lighting up the chat for me. I think he's lying again here. Because if I can understand it, the one girl that testified said that he fired her. I mean, she fired him. We didn't hear about any other of his clients testifying and dealing with prosecutors. I think Blackburn is lying to the court right here as well. And you know that Jake's team is going to bring that to their remembrance. I think he's lying, everybody. The judge says, I do think the context is important. And you raised the issue of context. The question that I have, though, is the accuracy of your declaration about the June 17th date. When, in fact, on May 27th, 2025, the plaintiff's opposition had already indicated and made the accusations that the May 5th brief, it contained artificial intelligence hallucinations, including misrepresentations of my own opinion. Is that right? Tyrone says, yes, 100%. So like I was saying, just to touch on that, I had already highlighted found cases and also highlighted and went through and highlighted the sections that were inaccurate quotations, and I responded in my reply brief with that. And I was in the process of fixing that and correcting. I should have done it faster. I should have done it sooner. I should have made it a priority. But like I said before, thank you so much, Londa, for helping us reach our goal on today. We only need 8 more, and we've reached our goal. You say he was fired before that girl. He was fired before she got on the stand, so that was not his client. He's lying. You said this is did better than oh my goodness. The judge says you raised the issue of your reply brief. So by my review of the record in this case, the first accusation that the May 5th brief was filed with misleading and misstated or non-existing quotes from cases was made. We immediately noticed the unusual non-quotation from my own opinion. They put on the record as of May 27th, the issue of artificial intelligence. You guys have to remember, he even misquoted, missed everything even the judge had said in the case. So he didn't even misquote just case law. He misquoted and manipulated, turned around and misconstrued even what the judge had said. So he did not do any research or work. He just put it all through AI. What's up, Regina? I received your reply. This is the judge still speaking. I received your reply brief on June 2nd. And the June 2nd brief, rather than striking or acknowledging mistakes that were made on the May 5th brief and withdrawing it, my characterization of the June 2nd brief is that it doubled down, and that our review of the June 2nd brief, independent of anything that we had received from them, was that the citations in that brief were as questionable, non-existent, misleading as the quotations in the first brief. Thank you so much, Mary, for helping us reach our goal on today. You said don't blame it on sunshine. Don't blame it on the moonlight. Don't blame it on the tacos and tequila. Blame it on the protege. Right. May 5th. May 5th. It was cool. Yes, yes, yes. Thank you so much for helping us reach our goal. We only need 7 more, and we've reached our goal for the day, our super chat goal. So the judge is still speaking. So although your declaration at ECF 57, paragraph 3, indicates that you were made aware of the AI issue by opposing counsel on June 17th, the plain record of the case demonstrates that the accusation was made on May the 27th, and that your immediate follow-up to that on June the 2nd was to double down on the AI and to accuse the other side of using AI. That's what you did, Blackburn, rather than taking responsibility at that time. Tyrone says, look, Your Honor, I believe that I took responsibility in my affidavit where I acknowledged that there were errors that I filed as part of my reply brief on the June 2nd. He told the Honor to look, Your Honor, look, Your Honor. Let me tell you something. So I just filed, filed my reply. I should have struck the issues, but I thought that the court course would have been was to just make the changes, the corrections in the actual documents and file them. But I did acknowledge that they were wrong and that they were inaccurate. The judge says, you acknowledged in your declaration? He says, in my declaration, yes. The judge says, but the first opportunity you had to make the acknowledgement, he says, no. I think I filed a declaration in my reply as well. I think. What are you talking about? If I'm not mistaken, I think I did. Judge says the reply brief as stated. No. I think I did. And then I added, I think I may have, I know I added attachments as well. The judge says, beginning at page 5 of my order of June the 22nd, it highlights a series, a representative series, not exclusive, but a representative series of misstatements of case law from the reply brief, which was filed on June the 2nd. One of the questions I have about that also goes to your explanation as to how the AI tool, based upon your misunderstanding, works, in that you would be able to put quotes around what you believed were paraphrases. Tell me, does Jackson versus Lehigh Valley Hospital, the case cited to me from the Third Circuit, does it exist? Tyrone says no. So what happened was, somebody typed that in the chat. So what happened was, Your Honor, what ended up happening is that there were mismatches of, so like it will take one title and like attach a citation. That's what I discovered through all of this, is that, that's an error that occurred. So it will take one title or one section from a case. It will take a case title and it will attach a citation at the end that's not accurate. That's essentially what happened. And again, I have no explanation for what I did not catch, why I did not catch that before I filed. The judge says, so it wasn't actually then merely putting quotations around the artificial intelligence summaries of cases. Tyrone says, no. So earlier I uploaded the actual I uploaded your order. I put a little summary of what the issues were. And then hold on, Your Honor. I wrote out the facts section of what I want the body of the memorandum. Then I submitted that as well as a brief history of what the issues are in the case. Then I selected the jurisdiction, and there's a function that allows you to upload documents. And that's what I did. I uploaded documents and different things from the court, what the question was, and then a part of those uploads were actual cases that downloaded from Lexis Tool, as well as some cases I downloaded from Westlaw. And I have the cases here. I did the research. I wasn't, I'm not trying to, say, I'm not trying to defraud the court or anything like that. Thank you so much, Jazz Harris, for lighting up the chat for me. She said, just take the whole law license away and throw them in jail. My goodness. Oh, Lord Jesus. I highlighted in a lot of documents that I selected sections that I wanted. And then I uploaded that into the system, and then it generated what it generated. And it was inaccurate. And I should have caught it. And I'm, Judge says, the question I have, though, is even with crediting that explanation, how did that lead to the citation to a case which simply doesn't exist? Neither in name, nor in citation, nor in the quotation that it attributed to it. Tyrone says, of course. So again, the issue is that it created this. I didn't do it, Your Honor. It created a citation. I don't know how. I don't even know why. But it just picked a name. And it picked a thing and just put it together and gave a quote. Oh, Tyrone, you need to stop it. Again, I should have caught it, I made a huge error on this. I should have understood this program a lot better and not used it actually, in doing this. And it's a mistake. What's up, J Boogie? T Davis? Of course she did it. There's the stuttering. The judge says, moving on to the declaration that she was tired of that. She was tired of that stupid explanation. She was tired of that. Moving on to the declaration that you submitted to this court on the 19th, just last week. You state to me that you practice law since 2018, a quote, and during that time, I have never encountered citation or quotation issues in any legal filing submitted to a court. And this is the first instance of this kind in my professional career. I've always respected the significance of Rule 11 and the duty it imposes on attorneys to ensure accuracy, factual foundation, and legal grounding of each filing. You mentioned already today the Combs case that you're a part of. Oh, Jesus, why did he even bring it up? Why did he even bring it up, y'all? Oh, my goodness. Thank you so much, Wade, for lighting up the chat for me. Let's put some more colors in the chat, everybody. We only need 5 more, and we have reached our super chat goal for today. Make sure you guys like the super chats, all right? Don't just let them sit in the chat. You like the super chats as well. What's up, Keisha? Imani? The judge goes on to say, he said, yes, you mentioned already. Yes, you're right. Yes. In the Combs case, it is not the case that Judge Oken of the Southern District of New York cited you for, quote, Blackburn's filings are replete with inaccurate statements of law. Is That not the case? Well, so I'll tell you what happened there. Again, I think context matters. So when I filed my opposition to the defendant's motion to dismiss, Sean Combs had just been indicted. And in my opposition, I said, I think I concluded that the indictment with him being guilty, and that was Judge Oakton, I believe, was referring to or getting upset about. But prior to that, again, I think context really matters, especially on that case. There was it was an extremely contentious time frame in that a lot of things happened in that case leading up to that filing, right? So all my devices were hacked. All of his devices were hacked.
I was rooting for you. We were all rooting for you. How dare you? Learn something from this.
He got to be trolling. And I had to file a report with the federal government. All of my files were wiped out in my case. My client's 7-year-old daughter was approached by some private investigators at her school and was being harassed. I had people following me, following my client. So there was a lot of things happening during that time that led up to that motion. Well, me filing that position, I was extremely angry when I filed it. And I said that, he was indicted. So therefore, he should, I guess the sum of it was he was indicted. So therefore, there's no need to dismiss any of the claims, because the same claims that we had in our civil case were the claims that he was indicted on in the federal case. The judge says, so Judge Coate on April 3rd, 2024, and again, I'm questioning the statement you've made in paragraph 2 of your declaration, ECF 57, state that Blackburn's actions in this and prior cases indicate a repeated failure to meet his Rule 11 obligation. And in that case, Judge Coate referred you to the court's grievance committee. And again, that was on April 3rd, 2024. Is that correct? Tyrone said, yes, 100%. Judge says, and that was as of March of this year. Judge Oakton notes in his opinion that you had proceedings pending against you in that court's grievance committee. Tyrone says, so I'll tell you this. I've never been contacted by the court's grievance committee for the Southern District of New York. And Judge Coate's opinion was based on the jurisdiction of the defense. So my client informed me in that case and my research showed that the defendants, which was a law firm, 2-partner law firm, was domiciled in the state of New York, Manhattan. My client lives in New Jersey. So my contract was to bill $75,000 at the diversity of jurisdiction. Now he tried to explain away. My client's assessment was wrong. I did my research on that and came out that the plaintiff, one of the defendants, lived in Manhattan. And the attorney for the defendants came on to the case files and said that, her client lives in New Jersey. Judge Coate felt that I should have listened to the attorney's statement about where her client lived. And I said, respectfully, unless she provides me with proof that her client lives there, I'm not going to just take her word for it. Ooh, Tyrone. She provided proof to the court, and then Judge Coate went through all of my filings from 2019 in the Southern District of New York, and found issues with different things. And that's what created that opinion. Judge Coate did what this judge is doing, went and researched other things and found a whole bunch of issues, Tyrone, with your work. Y'all hit the like button for me. The judge says, and Judge Coate made that reference to disciplinary or the grievance committee, which I presume is a disciplinary committee. Tyrone says, I've not gotten a word from them. Judge says, but that was made in an opinion that is of the court of April 3rd, 2024, correct? Yes. And you were aware of that? Yes. Okay. The reason I asked that was April 3rd, 2024. Your pro hoc vice, VJ, application was filed before this court on January 15th, 2025. That's at ECF number 33-1. And at page 1, y'all listen up. And at page 1, subsection 3, you state, I have never been the subject of any disciplinary actions, suspensions, or disbarment by any bar, court, or administrative agency. You omit Judge Coates' reference to the disciplinary committee of the Southern District. We talked about that here, y'all. I said, wait a minute. When we read that, I said, no. We have been hearing of him having disciplinary things brought up against him. And then y'all hit the like button. At least give us 200 likes in here, y'all. At least give us 200 likes. I remember reading that and saying, this guy is lying from the gate. Because we all knew that he had some disciplinary stuff going on and some grievances. Blackburn says, Your Honor, I've never been, I'm letting you know, I don't know what, how that works. This nigga don't, excuse me. This Negro don't know nothing. But I understand from a recent situation with, I believe, Attorney Tony Bugsby in the same court in the Southern District of New York, where Judge, I think it's Valez, referenced him to the grievance committee. Why are you bringing Bugsby into it? We're talking about your grievance. They acted right away. I've never been contacted by the grievance committee. I've called to inquire, and they have no record of it. Oh, I don't believe that. I don't believe that, Tyrone. So again, when I wrote that, I wasn't lying. I've never, the State Bar of New York, never contacted me with any kind of grievance issues. You probably told them to kick rocks so you didn't answer your phone. We are reading the transcripts from yesterday's hearing between the judge and Attorney Tyrone Blackburn in the Bishop Jakes lawsuit against Dwayne Youngblood. Bishop Jakes is at the court. He was there at the court on yesterday, okay? He was there. Bishop Jakes means business. Okay. New Jersey, this is still Tyrone talking to the judge. New Jersey never contacted me with any grievance issues, and no federal court has ever contacted me for any kind of grievance issues. The judge says, you just believe nothing came of Judge Coates' referral? Huh? Blackburn says, your presumption was that nothing came of Judge Coates' referral. Blackburn says, not that nothing came of it, to say that she referred me and then I contacted the office and there was no referral. I don't know how the process works. I'm not a judge. I don't know what the process is to refer someone to a grievance. Was it Madison and Prim? The judge says, moving on to your she got tired of that lie too. Moving on to your declaration 57-1. At paragraph 12, you stated that you have voluntarily taken CLEs dealing with artificial intelligence to help understand, including number one, an ABA class entitled, quote, AI is changing the legal profession, but not your ethical duty, unquote. What date did you take that? Tyrone says, I can tell you right now, I took it on July 18th, I believe. Last week? Yes, Your Honor. As I was completing this and drafting this, I was looking up the AI and all of the other stuff. I started seeing CLEs popping up. So I decided to take them in order to gain better understanding and knowledge. So I took 3, 2 from the ABA, 1 from, I think it's T. I don't remember the acronym. Lord have mercy, Tyrone. Judge says, do you have certificates of completion? Yes, I have them. I can upload them. I can provide them to the court. And then I also have I took additional CLEs with the New York State Bar Association as well. I signed up for some of some for the New Jersey as well. Now, y'all remember he had to get that paperwork in. I think it was like the 11th, 18th. But wasn't that after his? He had to get his thing in on the 11th. So he lied on his briefing and said he had took CLEs. Wait a minute. Let me think about this. Or he took the CLEs the same day he submitted. Yes, he took the so-called CLEs the same day that his response was due. Tyrone Blackburn is a liar. He's a liar. He's a straight up liar, in my opinion. I just, I'm trying to make sure that I completely understand the thing and not make this error again. The judge says, number 2, complete your CLE request and program evaluation, catching up to AI ethically. How existing ethic rules apply to artificial intelligence and how to guide lawyers in avoiding ethical pitfalls. Who sponsored that CLE? Tyrone says, that was T. That's the one whose name I'm looking up. I have the certificate, Toe. What date was it? The same date. I took them all. I took them all. They said, judge says, on July 18th? Yes. Yeah, I took them all. All 3 of them? All 3 of them, yes. How long were each of them? I believe, I don't want to misquote, so I want to confirm. It's only been the judge says it's only been a week. He says, he breaks in and says, I think like an hour and a half, 2 hours, 2 hours. The one was only 2 hours, and the other 2, I believe, were an hour or an hour and a half. I don't want to misquote. The judge says, so the TRCLE, artificial intelligence and legal practice, same answer to that. The 18th? Is that when you took them? The 18th? Yes. Judge says, so today my specific questions with respect to your declarations are finished. But as you know, we are here today on in order to show cause why you should not be sanctioned. I will allow you the benefit of having the last word on that question. And the question is, if you can give me now your summation in light of your admitted failure to the review of your own briefs to ensure that those briefs were cited real case law with real quotations, sometime in real cases, why should I not issue a sanction? And if I should issue a sanction, what sanction should I issue? Tyrone says, well, Your Honor, like I said before, I take full ownership for what I did. I'm not, coming here to make any kind of excuse. I should have been more diligent with what I filed. There's really no excuse for it. Well, you had plenty. I completely understand what my Rule 11 obligations are. I was raised by Marines. So I'm not going to come in here and make an excuse for what an error on my part, which I should have been more careful for. So if the court feels that I should be sanctioned, I'll leave it up to you, Your Honor, to make that decision. I will fall on the sword and take whatever the court deems appropriate in this context. Father, I stretch my hands to thee. No other help I know. If thou withdraw thy help from me, where should I go? Tyrone said he's just going to fall on the sword. The judge says, okay, understood. So the other question that I had today is, there has been an indication that the plaintiffs, as part of any sanction, and the courts will review the record as well as the case law, and there's a prevailing body of case law developing around this very issue before I make my determination as a threshold matter as to whether sanctions are warranted. But if sanctions are warranted, one of the things that cases have done in award attorneys' fees. In this case, the attorney's fee in my mind would be the relief brief. Well, the responsive brief, analyzing and responding to the May 5th brief. Are you prepared today to present evidence as to the amount of fees that your client incurred as to the analysis of the May 5th brief and the response thereto? Attorney for Bishop Jake says, Mr. Push, thank you, Your Honor. I appreciate it. Dustin Push on behalf of the plaintiff. I think we would respectfully request to file evidence of the appropriate fees that we believe should be warranted. And we do request that fees be rewarded. I think that certainly the work that went into the from our perspective, and it was a relief to hear that the court was discovering exactly what we were discovering as well at the time as your order. The judge says the court generally, it's familiar. It's one thing when I cite someone else's case. The court is generally familiar with what I wrote myself. Oh, Lord. Oh, she said, I know what I said, and I know what he misconstrued and lied about. He lied about what I said. He I know what I said. And the Negro came in here and lied. Mr. Push says, absolutely, Your Honor. We expected as much. Nevertheless, of course, we've got to do our own due diligence at the same time. Certainly, the opposition brief, in which we had to spend significant time and energy to uncover exactly what was going on. Obviously, responding to a motion to dismiss is a lot of work unto itself. But there, as my declaration states, there's the incredible amount of work that goes into uncovering these types of misrepresentations that are in a brief. Lord have mercy. Tachi says he willing to take this hit, just get off the case. Does he know JT will be coming? Ooh, let me tell you, they coming. They are coming like a vengeance. Vengeance. Mr. Push continues to say, I will say by anecdotal of my own experience of this was reading the quotations from this court's opinion, the supposed quotations, and personally feeling like I was going crazy, not knowing what was going on here. The man thought he was crazy. He thought he was like, I don't even know what I'm reading. Am I reading this right? Rereading your order over and over again, figuring out what was going on. And I'll leave it at that. But I do believe that we would request that the fees go beyond just the opposition brief. We were forced to file a motion for surreply, and surreply that not only called out the additional misrepresentations, but also had to defend my law firm and my counsel's law firms and plaintiff himself from the false accusations that we misrepresented case law. They standing up for their own integrity. They said that he tried to tell us. He tried to tell us a few things. What is going down with the Mr. Official King Payne? King Payne he's on the wall too. He stayed that not some of them have can't find him no more, King Payne. They off. They're not reporting this. Oh, but we on the wall. Mr. Push continues to say, attorney for Bishop Jakes, we requested consent to file that surreply. That was summarily denied by Mr. Blackburn, telling us specifically that we were not to get another bite at the apple in filing that surreply. Wasn't he just an arrogant little heifer? To me, that does not sound like he's in the midst of figuring out what's going on, in the midst of fixing it, especially on the heels of the reply that he filed. Moreover, the testimony from Mr. Blackburn in his declaration and today is that it wasn't until sanctions motions were served on him. We've never filed it. We served it on him in accordance with Rule 11, following all of the rules. Despite all the knowledge of what was going on, of course, we had to do that. That's what the rules state. It was after that he's now claiming he began the process of fixing something. Moreover, it was only after that we finally got any word whatsoever from anyone from defendant's counsel about what was going on here. In my practice of law, I've never seen anything like this. And I expected at various different points of this process that we would hear something, anything about this. We did not. Y'all hit that like button for me. Oh, I get so tired of asking y'all to do that. I don't understand why y'all just can't hit the like button. That's weird. That's weird to me. Crazy, crazy, crazy. So we would humbly submit that our clients' out-of-pocket fees for paying to uncover this and continually have to have a completely unnecessary fight about this and continue to have to submit briefing and filing after filing to finally get across to someone this issue here. Of course, not to this court necessarily, because you were discovering it on your own, but to counsel. I would humbly submit that our fees should extend just beyond the opposition and go to the reply as well. The judge says, so to answer my question though, today, you are going to elect to wait to see if and what, if so sanctioned, this court imposes before submitting a reasoned fee petition with numbers. We welcome the opportunity to submit that before. We would submit it before, but I defer to the court's guidance. Do you have it today? We don't have it today. We have to put it together. We could put it together pretty quickly. Ooh, we may see that. We may see it really quick. The court, the judge says, is there a reason you don't have it today? You came in here for this hearing. Okay. You were invited to come here for this hearing to the extent that you were going to present a fee petition. Is there a reason it's not here today? The judge said, you should have had your fees with you. He says, I apologize, Your Honor. I may have misunderstood. My understanding was to appear whether or not we were going to request it. We have invoices. We have redacted invoices that we can present to the court very quickly, and we prepared them. I just don't have them ready to hand to you right now, but we can provide them probably tomorrow, along with a petition, if not the end of day today. Let's look on here to see if any fees were submitted to the courts. Hold on, y'all. Let's check the books. Ooh, I can't wait to see how much they finna stick this man. You're gonna stick him. Let me see here. It's on the docket. Let's go. Okay. Let me see here. See what this is. Okay. All right. No, not yet. Not yet. They don't have it yet. They don't have it yet. They don't have it yet. What did you say? St. James, once they submit their price tag, does that mean Blackburn himself has to pay the restitution, or the law firm which gave him the okay? I believe that's Blackburn. That's Blackburn. This is all Blackburn. I don't think the other law firm is necessarily in trouble yet. I don't know if they ever will be. But I'm sure the judge is going to probably reprimand them in some kind of way for even not doing their due diligence as to seeing why they didn't vet Tyrone Blackburn before they agreed to sponsor him. So the judge states, here's what we'll do. I will give you until today is Thursday. I will give you 7 days. Okay, Your Honor, okay. To supplement with a formal fee petition with any kind of supporting information, Mr. Blackburn, I will give you 7 days thereafter to respond. Here we go with some more dates, y'all. They got 7 days. They're down to 6 days to respond with their fees. Blackburn can lie. He can respond with his lies and grovels after that. Blackburn says, okay. And then what I'm saying that I'm going to find that that sanctions are warranted, or if sanctions are warranted, that fees are the type of sanctions warranted. But I want to have a full record before me before I ultimately make that determination. So you have 7 days, 1 week from today, Mr. Blackburn, you have a response within 7 days thereafter. And then after that time, roughly 14 days from today, you will hear from this court in very short order a resolution to this issue. Thank you, Your Honor. Judge says, anything else, Mr. Blackburn, before we adjourn? Blackburn says, I just want to just follow up and reiterate that I had already begun outlining. As I explained to the court, I think the court asked the question regarding why I had not, I guess it was like why I had not made the changes. Since the opposition brief, I had already identified all of the issues in there. He was sitting there thinking of some more stuff to say, y'all. I just want to reiterate to the court the circumstances that I was involved in, plus the fact that I had identified it. But again, I don't know. I just didn't have the ability to move as quickly as I should have moved. I would have wanted to move. The judge says, look, I appreciate that. And like I said to many people that sit in that chair in other contexts, I appreciate when somebody comes in and takes responsibility. I do. I guess what puzzles me in this case, Mr. Blackburn, I alluded to already in my order scheduling today's hearing, is that for an attorney who takes Rule 11 and frankly his professional reputation seriously, when the other side accuses you in a brief of filing a brief repellent with nonsense to the court, including completely misquoting the presiding judge's own opinion, I think that due diligence would leave more reasonable lawyers to immediately take action to figure out what happened and to resolve it. 100%, Blackburn says. Judge says, but that's not what you did. What you did is you filed a reply brief that included more AI, hallucinations that made up a case that doesn't exist from the Third Circuit, and then, as they indicate, offers a tu quo, I don't know how to say that. You also defense, saying to them, your brief is full of artificial intelligence. Told them that. Told Jake's attorneys that. Well, we did a cite check of their brief. Their cites and their quotes worked out. Judge is saying we didn't only look at your foolishness, but you accused Jake's team of doing AI, and we looked at theirs. But the judge says their cites and their quotes worked out. So I guess I appreciate your coming in today and falling on your sword and opening up to what you did. I do appreciate that. My concern is, though, in real time, the initial response was not to take responsibility, but it was to double down and make accusations. And that's what I struggle with, is balancing when I go back into the chambers, when the record is fully complete before me, and I sit down with the case laws that's developing in this area. What I struggle with is balancing, and this court balances all the time, multifaceted issues, balancing your acceptance of responsibility today on top of what you did in real time. And ultimately, my decision will make that balance. But I guess that's my problem, though. It is continuous today. As you come in here, you're taking responsibility, but not making great explanations for what you did in the reply brief. She's otherwise said you take responsibilities, but you're lying. You're lying. Blackburn says, look, yes. So the brief, I'm trying to defend my former client's position of having the case dismissed. But in the affidavit, I explained what the issues were. But you're 100% correct. I should have immediately filed the corrections, then as opposed to just focusing on the reply brief and then working on getting it done. But again, my attention was on another issue, which again is not this court's problem to deal with. The judge says, "Do you apologize?" Tyrone says 100%. The judge asks, "Do you apologize to your opposing counsel?" Tyrone says, "Yes, I apologize to them. I'm very sorry for all this confusion that I created. You wasn't sorry when you was running your behind over to these platforms and antagonizing Bishop Jakes. But now you're sorry. Yeah, you're sorry. You're sorry." No, just play. And you know for what he said, and you know for even having to come and deal with it. I should have been more careful and more clear with what I do, Honestly, there's nothing else for me today, honestly. I'm just beaten down and downtrodden. And I have made a lot of changes, not only on this case and beyond this issue, the language, I do what I do, the people who the court. Okay, okay. I appreciate that. We ain't got time for TED Talk. Anything else before we adjourn? Attorney Push says, "Yes, Your Honor. Part of this with regard to the fee position, the reasoned fee position, there's no protection order in the case as far as submitting invoices that may have privileged information on it." The judge says, "I'll sign a protective order." Y'all want to read that again? Oh, God. Mr. Push says, "Okay, thank you. Appreciate that." The judge said, "That goes without saying. Anything else?" Okay. We're adjourned. Whew. Took us an hour and 19 minutes. What do you guys think? They tired of Blackburn. They are tired of Blackburn. And I believe this judge, by going back, and that Jakes' team brought up all the other grievances and admonishments and things that he did get up against him, that he lied in the initial deal, the pro hoc fight, when he was trying to get a sponsor in Pennsylvania. He lied. And then he goes in and just talk about he didn't know when nobody called me. Well, first of all, nobody called because you run over your process servers, and when they try to give your client some stuff, you tell everybody to pave the ground, pave the sand, kick rocks, go find them, get good luck. So they may have been trying to call Blackburn, but he didn't quite answer the phone. That's why folks are selling. Let me tell you this, because let me tell you something, Sean Talks show. If y'all don't know nothing by now, let me just tell you that this man, Bishop Jakes, is not dumb. And by him showing up in court yesterday, he is willing to show up in court any day that he has to show up in court. And he is going to take every defendant, every co-conspirator. He is going to bankrupt you. He is ready to fight the good fight of faith. So y'all better sell everything not nailed down so you too can have a team of attorneys like Bishop Jakes, even though we know that's not going to happen. Because even if you run around here talking about you're innocent, Bishop Jakes and his team don't believe you're innocent. They believe that you're extortionists. They believe that you are conspirators together, and they believe you have defamed them for the very last time. Even though some of you, even after the case was dropped, handed into Dwayne's hand, some of you decided to continue to defame Bishop Jakes. So I'm sure they got all of that downloaded, and they are ready to fight you as well. As long enough you have your proof, as long enough you have your evidence to bring it to court, I don't think this whole First Amendment thing is going to work. You don't have the First Amendment when you stand and say you have in fact evidence that this man is this and this man did that. Produce your evidence, because it's never been produced to the world. We've been waiting. We waited for Manasseh's orders to drop. We waited for a lot of things to drop. 7 days, 10 days, 24 hours. You call me. You better call me. I'm going to do this. You better do this. We're going to do this. And none of that ever happened. Bishop Jakes is tired of y'all's ass. And he's ready to fight. He's already been fighting. And it looks like he's winning. Because by the time they get finished with Blackburn and sanctioning him with all these fees. Now, if fees is just one thing, they can sanction him. The judge can sanction him with something else. This judge has to speak for all the judges that he's been in front of that wanted his law license taken away. He has to speak for these other New York courthouses. Because if he doesn't, and they let Blackburn continue to get away with how he treats the court, the blood is going to be on this judge's hand in Pennsylvania. Because he's been given a gift. He's been given a gift to discipline this attorney. He's been given a gift to make this attorney be a better attorney. But if they let this go, Blackburn is going to continue to be the foolish, arrogant, ridiculous, childish attorney that he has been. So I believe either y'all better get your passports and get the hell out of the country and hide under a rock, or you better have your attorney on deck to fight Bishop Jakes. Because I think they're going to come after Tyrone Blackburn too. Because in my opinion, I believe they believe he's part of the conspiracy. He's part of the extortion plot. And he's delivered a lot of information to the public in regards to a possible extortion with these demand letters that have lies in them just to grab the people's attention so they can just throw him some cash. It's my opinion, but I don't know. Time will tell. I'm going to drop this, but if you come up, talk fast. I ain't got time for slow talking and all that. Talk fast and name your point. Let's hit this. Name your point. This petition or these transcripts will be in Patreon, the St. James Show Patreon. It's pinned in the chat. If you would like to have these transcripts, you can go there, pay the $10 tier, and they will be there in Patreon if you would like to have them. Okay. Yeah, talk fast, T. Davis. Talk fast. Yeah. So when I read the first of that and they said that TD Jakes was in the gallery yesterday, I knew that we've been knowing that this deal is really heating up and it's really taken a turn of what people thought it wouldn't take. They thought they were going to get money and it was going to be over with. The only person going to get money is TD Jakes. That's the one who's going to get money. And people will run around here still that it's okay. You know, they'll start talking about the victims. The victims. Oh, people forget about the victims. Bring us one, and we'll be on there. We'll be up. You know, we'll hold them up in their plight. We don't have a victim yet. Mary.
Hey, how are you?
I am good. So, your thoughts?
Child, the way that man was fumbling but bumbling, he blamed it on the protege. He
Everything.
put CLEs and I have this, but I didn't know I needed to bring it. Huh?
How you do all the CLEs in one day?
Huh? And depending on which courses he did, they put timers on there.
They do.
So you can't just skip through the material. Yeah. But okay, so I just wanted to clarify because I'm like halfway working.
Okay.
Now, that last part, that was Jake's attorney requesting for privilege information to not be released? Okay.
Right. Yeah.
Okay.
That was Jake's attorney. Yeah. They wanted
did he, so throughout all of that, he's going to give him the 7 days. And then at that point, is he going, like, what did he say about letting him withdraw as formal representation? What did he say about that?
He hasn't mentioned any of that yet. He didn't. Okay. That wasn't an issue in this hearing. But I'm guessing, because he hasn't been released yet. He's talking about his former client and all that. And we know that Summer and them are working with Young Bud now, but he hasn't been formally released. Because the judge said you need to go to this hearing first. You still need to be on the case as his attorney, because you're going to be sanctioned as his attorney.
Gotcha. That's what I thought, because I was like, okay, so he's still not off. That's exactly what I thought. I'm like, he's not off the case just yet. So yeah, I mean, I see there's some problems ahead for a few people.
I see that. Yeah, me too.
And I think that it's wise for them to stop being in denial about it, I guess you could say, because he said what he said. And I feel like the message is clear for the dumb ones on the short bus over here. But yeah, the fact that he showed up, like, no, y'all aren't gonna, you're not gonna bully me. I'm not going to just, but I'm just so puzzled at him. I'm sorry, but you were so confident and so cocky.
Arrogant, so disrespectful. Just, me, it's like us over here. We got this in the bag. I mean,
yeah. And I'm doing this for little Tyrone, who looked to Jake's as a mentor as well, and was mistreated. And and I mean, just to lie about not being like called out for his previous errors. Like, how are you going to lie about that?
And knowing good and well that Jake's team got time. They're going to make sure that the judge knows each and every thing that has come up against Tyrone. But to lie and say you were busy at the Diddy case because your clients were testifying. You didn't have any clients testifying. The only one woman said she fired you.
And not only that, you got kicked out.
Right, and you got kicked out of the courtroom. Did you tell that part? Tyrone? You got kicked. One of the days you got kicked out of the courtroom. And he was over there with Little Rod, and Little Rod's case was it was thrown out as well because of the lack of proper documentation to the courts, as usual, with Blackburn. So he lied to this judge today and said that he was busy with the Diddy case. You didn't have any dealings with the Diddy case.
Yeah, you had no client. You were just trying to be there as a spectator. What did Armand call him?
A clout
The clout
chasing.
chasing, yeah, the clout chasing. How's it feel to be a clout chasing attorney? I
Yeah,
feel like Jakes and them are obviously going to take like clips of all that kind of stuff and his behavior and
yeah,
just like
yeah,
more of his patterns,
yeah,
because if they sanction, well, when the sanctions come down, I should say,
yeah.
can he still technically be let off the case to be listed as a co-conspirator, or do the sanctions have to be paid before
I
he
don't
can be
know.
let go?
Those kind of. I'm not an attorney. I just
Yeah,
know. But my thing is, once he's let off the case, he's no longer that man's attorney. I don't see
right.
why they couldn't sue him, because all this works in their favor. They can say that he was trying to manipulate and trying to mess up the case and prolong the case because he knew he was one of the co-conspirators.
Mhm.
They can flip all that and say he did all this on purpose because he did not want them to, you know, get to the point where they're going to be naming him as a co-conspirator. Because my issue is, I mean, from what we've been presented with, I don't know a lot of the only people I know that we can even assume to be co-conspirators, assume, is Larry, Richard Youngblood, possibly, and Tyrone Blackburn.
Mhm. Exactly. Those are the
They may
only
not be,
ones
they may not
who,
never be named, but I mean, according to
yeah,
the documents that
yeah,
we're
because those
reading.
are the only ones who appeared on the podcast and
Yeah.
or submitted
Hmm.
documentation. Because it was, yeah, because what was the one who wrote Todd something Ford something? Who was the other one that wrote the affidavit that used to work for Jake's?
That said he seen him naked.
Is that what he said? He saw his booty? I don't know.
Yeah, yeah,
Because
yeah,
I'm
yeah,
just
yeah,
like,
yeah,
whatever they, because
yeah,
I'm just like, I
yeah,
wonder, because I'm like, the fact that they roped him in on it,
yeah,
like,
yeah,
who all did you guys promise a check to
yeah,
for
yeah.
those statements and for all of that? Like, it's not gonna be pretty.
It's not. It's not. This was a $6 million grift that just went to the hell in the handbasket. It just didn't work out. It just did
Mm,
not work out. Found
mm.
yourself before a judge. You went in pro bono and come out paying.
Hmm.
How you go in pro bono
A good
and come out paying
citizen.
thousands of dollars to the
Mm,
opposing
just
counsel?
doing his due diligence to protect those young ones and those people
Disabled.
violated by the
Mhm,
powerful
mhm,
people in
mhm.
the spiritual realm and the church
Yeah,
world. Ooh,
yeah,
Lord,
yeah.
look at him.
Hmm. He
Her
said,
little
I
two
throw
teeth.
myself on the sword.
I apologize. I apologize. I apologize.
And she kept going back to, kept going back to,
Right, because
he
how many
did this.
times did she had to say, okay, so my question is, on this date,
Mm-hmm,
you
mm-hmm,
ignored
mm-hmm.
plaintiffs telling you it.
Yeah,
And
yeah,
you repeated, added, and continued to fabricate
yeah,
through all, like, how many times did she have to say that to him?
right.
Answer the question,
But
because you
go
won't
ahead.
answer.
Yeah. Mm.
I'm just like, he just refused to answer straight. They
He
had to
didn't
keep
have an
reminding
answer.
him,
That's because
like,
he
your
didn't have one.
timeline.
Yeah, yeah.
And the timelines have always been shaky from from the very first podcast.
It has. It has. And his last deal, he presented one day late. He was supposed to be on the 18th, and he
Right.
presented, I guess he presented on the 9th because he was doing all those CLE courses. He was doing all those courses the day. How you do it the same day that you doing all these courses the same day you have to reply. That's what I'm saying. He's a liar. And that judge
Yes.
does not believe him. I know that judge does not believe him.
Right. And you said yourself, I don't have enough hours in the day and blah,
Right,
blah, blah,
right.
blah. But
And
magically
everybody.
on that day,
Mm,
you found all the hours.
right, right. To do all of those courses. But didn't quite know how long they take now. And I got the completions, but I don't know where they at. I don't know what my certificates went. Yeah, lost those.
I have this, but we also have a redacted one that I could find it for you. I just got to get it out the garbage can, or maybe it's floating down a river somewhere.
Oh man.
Oh my gosh.
You know, I feel sorry for the everybody involved, that like the defendants, because they really convinced themselves that this was going to work. They thought that they had tormented Bishop Jake so long and embarrassed him so bad that he was just going to pay them off and they were going to live happily ever after in another country somewhere.
Yeah,
it didn't work. It's not working. Go ahead.
For me, the level of delusion is just mind-blowing and perplexing, because I just don't understand why, as soon as he filed the suit, was all that hard evidence not just leaked.
Right.
You have enough mouthpieces.
Right.
Everyone was saying they saw with their own two eyes, but nothing leaked out.
Or, you know, why didn't you present all that to Jakes after they denied your request, $6 million request? That's the time when you start sending in your proof to them to say, listen, I got this. You know, like Cassie did, I got the book right here. I'm ready to go with it. And you know, all of it in here is true. Why didn't you go back to Jake? Y'all don't want to give me $6 million? Okay, well, here's my evidence. Here's the proof of what we're gonna put out there, because there was nothing like that.
Nope,
there was nothing like that.
Not at all. But I just, it's disgusting. It's really disgusting that they really thought it was going to work, and the length at which they went to.
Yeah.
And, you know, these are men and women of God.
Yeah. Men and women of God. And, you know, that whole grooming thing, that whole, people, you know, groomers calling other groomers, you know, that just blows my mind. My mind, you know, but nothing happens to you. You know, you just can go off but we gonna sue the big kahuna groomer, you calling him. No,
right. Look, class is in session. Everybody sit down, get your calculators out, pull out. We gonna have a crash course, and you need to figure out how to save your ass right now.
Right.
Because where the money gonna come from, young bud, get your little snitch story together.
Well, you know, they are over there trying to bail out. Young blood over there trying to bail out. He don't know nothing. 3 blind mice. He over there. He has no idea.
It's a crash course. They better start crunching those numbers. Like, apply for a couple more loans. They better do something, because they got to afford their own attorneys at this point. And
I'm wondering, does Summer Law just taking this because they agreed to do it in the beginning? Because I think
they're trying to do it. Yeah, they want to cover their ass, because they stuck their neck out.
They have to cover they really have to, because that judge is looking at them going, you should have vetted this guy.
Absolutely.
I shouldn't have to deal with this, because no one should have been able to give him pro hoc vice anywhere in this state after seeing what he did in New York.
Exactly. What lie did he tell you that you guys failed to fact check? Because they have to cover their own ass at this point, because they're on the hook.
Yes. Yeah.
But they're gonna get exactly what they deserve.
They probably asked him, you know, did you see the letter? Why did you send the letter? And then they said, no, he's saying he didn't see a letter. The only person we know saw the letter that says they saw it was Larry Reed. And
you don't think you're a co-conspirator when you said it in front of millions of people?
The one being sued says he didn't see it. It's saying on the record that he didn't see a letter.
Right. And I believe, because mind you, whenever Tyrone did his wonderful little surprise pop-up, oh, this is my first time talking to you. I believe
we never believed that, Tyrone. We never believed that whole little act y'all put on over there. We never believed it.
Yeah, but didn't he say when he was reading the top of the letter, didn't he say he received it from Blackburn's
I can't recall where he said he received it from. That's just what I don't. And that video is probably down.
Yeah, I'm pretty sure somebody clipped it. Probably
I'm sure somebody clipped it, but I don't recall if he said Youngblood showed him or Tyrone showed him.
Right, because I feel like he said he received.
I don't care if you see the top, middle, bottom. You said you saw the letter,
and he knew that it was like, put it like this: the top part that he saw said that they were getting ready to pursue Jakes. It was clear. So yeah, I'm gonna have to go do my own research project because I want to know if he said that he got it from Youngblood or if he said Youngblood's representation sent it to him. Yeah. Because how are you gonna have a pop-up live and pretend like you ain't never spoke to the man, but you had the top half of his letter?
And we're still trying to figure out exactly how the connection came. Who gave Tyrone Blackburn's information to Youngblood?
Yeah, well, that's what I was telling Marcellus and them. When he said that 9 months, that would take him at minimum back to October.
Yeah.
If Youngblood was out, I guess someone said maybe August.
I think it was August that he got out. Yeah.
Yeah, so clearly he was talking to Larry, but at some point.
When did those conversations start? Did they start in prison?
It started before the videos came out because, well, the first one dropped end of October or first part of November?
October 28th. Yeah, it was the end of October. Then the first
exactly. And so if you've been working a full 9 months on this case, the video dropped and you knew about the case.
Right.
So like these timelines are going to get them every single time, because if you've been representing someone for 9 full months, you knew about this before the interview was going to drop. But yeah, I would want to know if he was on any of those conference calls or if there was any text messages like, hey, I talked to this guy in jail. He had dealings with Jakes. Yeah.
That whole little, I just saw a post and we connect. That may not be the truth.
Yeah, because he said
the man's a proven liar. I mean, we read. Well, I mean, we read what he lied. He lied today. So it's interesting when the true connection, when all the whole mob squad got together.
Because, granted, what he's supposed to be submitting is factual. 9 months would definitely loop them into a ring together if you did not intend on taking him on until end of November or whenever the case was filed. So you were clearly working with him before the lawsuit was filed. And clearly there had to have been some sort of conversation between all of you, because why does the podcaster have the top of this just as a friend? He's your media source.
What would be their benefit of seeing this letter? What would be the benefit for him seeing the letter? Why does he need to see it? He wasn't going to show the letter on the show. Why was it necessary for us to know that you saw the top of the letter?
Yeah. So to me, there's just a lot of gray area that they can't quite, put some facts behind. But yeah, I think the timeline, phone calls, text messages, all that good stuff. I'm like, can we just get to discovery already?
I know. I mean, that kept these 7 days, 14 days. I'm like, Jesus, my God. But I think this judge, soon as he has his opportunity to respond to their fee petition, he gonna come right back out and lay his sanctions right on the right there.
Yeah, but what they cannot say is that the judge has not been fair, because, like you said, just got 7 more days. To fabricate some more evidence. So you cannot say that they have not been fair.
But what else is he going to say in response to their fee petition? I'm sorry.
I got hacked. My car got broken into. Oh, the day that I ran over the process server in my and then my car went.
Come up. I'm surprised that didn't come up. Maybe because
I feel like they're gonna hold on to that if he gets dropped as attorney, so that way they can bring it in with the whole conspirator evidence.
But I think also that really didn't have that didn't have to do with his Rule 11 violation. So the judge had to keep the main thing. Yeah.
But I'm just
that's there. That's there.
It's like, so he's gonna have to figure out, like, so I had gotten locked up and they lost my personal belongings, which just so happened to be my briefcase that had all of those confirmations in it. They lost my stuff and evidence at the police station.
Because I'm being followed, Judge.
Right, they're after me. Look, at this point, the big burly man got people stalking.
Yeah, he gonna blame it on
Fat Joe got all the burly men. The Fat Joe stalking him, the burly Jakes is stalking him.
Listen,
he got people on him.
Fat Joe is on to him too. His problems have grown astronomically.
Oh, and yes, that's snowball.
Mary it's going to set the precedent of what we do going forward as bloggers. I know we looked at the Tasha K thing, and this is really, they had to produce that Cardi B didn't have the herpes, right? Regardless of if she paid a doctor to say she didn't have it, that wasn't the case. It was produced that she didn't have it. This particular case is just a bunch of hearsay and someone's so-called life experience. So it's different. It really speaks broadly about defamation in regards to your so-called life experiences. You may have had some unfortunate life experiences, but if we were able to come out and just defame people that didn't treat you well, or you didn't treat you well when you were a kid, when you're a teenager or whatever, then you can just come out. That would that opens up a whole book of worms for a lot of people. But this particular case, I think we never want to shut the mouths of true victims.
Exactly.
We never want to shut the mouths of true victims. But coming with being a victim, we hope that you can actually produce something that will allow us to stand beside you for justice.
Yeah, because even like with, the Gigi Lovey stuff, at least she feels like she had the text messages of manipulation.
But he acknowledged, yes, we had a relate. Now, was she wanted more? Gigi wanted more.
Yeah.
Gigi
so it's just like
more. Yeah.
I feel like it's hard, obviously, as the victims to probably say something right away. Who should they tell? Who won't judge them? Especially if it's, a beloved leader. Everyone's going to try to believe the leader. Oh, and then I know someone, or like some people are just like, they just be like, oh, that little girl's fast. She just be making up stories about everybody. Yeah. No, the neighborhood has manipulated and violated her.
Yeah,
it's not lies. So there just has to be a better way to figure out how to protect the victims and to help them feel more not necessarily inspired to tell their stories, but just more brave to be able to say, like, I can tell my story truthfully and be able to be believed versus I'm just trying to get money.
Yeah, when your story right there, when your story is rattled with a $6 million grift, it's hard for us to go with it. It's hard for us to go with it. And especially when it's not something blatant SA that's been described. You can say, have your interpretation of a hug and a missed kiss. If that's in your mind, want to say that's SA, then you can do that. In my mind, it doesn't look like that according to other SA victims.
In court, according to his own SA stories.
Right. His SA victims were SA'd.
No. I'm talking about him. He said it was Jake's and the two others. of the two,
Right, the preacher.
so I'm saying even according to his own personal essay,
Yeah.
like I get the one guy is dead, but why aren't you going after? Oh, because the
Yeah.
other guy doesn't have money. So it's like,
Right.
yeah,
You don't have Jake's money.
exactly.
You don't have
So
Jake's money.
you guys have been outed.
Right.
Your plan is you're having a crumbling tower. The Humpty Dumpty done fell down the wall.
Yeah.
All the king's horses and all the king's men. What y'all about to do?
I don't know. I don't know what they're about to do. But thanks for coming up, Mary. I appreciate you. I got to get out of here. Do something.
All right. I'll talk to y'all later.
All right. Bye. Yes, Leah, Jakes was in court on yesterday. He definitely was there in court. He means business, Leah. All this other stuff people talking about, he's dumb. It ain't gonna get off the ground. Oh, it's off the ground and it's down the road. It's down the expressway. Oh, that's where it is. James made an appearance. I don't know who James is. Okay, maybe you meant Jakes. Boots on the ground. Let me tell you, it is. But again, that's how people have been trying to manipulate this story, trying to go along with Dwayne and trying to mix it up with other true victims. We're not doing any mixing of victims here. We're talking about what we're talking about. We're talking about a $6 million grift that has gone awry. A $6 million grift from a hug and a missed kiss, a kiss that didn't happen. And from that, people wanted $6 million from Bishop Jakes. So don't bring me any other real victims. Real SA victims has nothing to do with this story. People try to get up there and try to do lives and stories about, no, let's not mix ain't got nothing to do with this story. Ain't got nothing to do with this story. We talking about Dwayne Youngblood and his foolishness. That's what we talking about today. And all the other people surrounding him that wanted a little piece of the peach cobbler. Yo, it got wings. It's flying. Like Patti LaBelle is flying. Appreciate y'all for coming through today. If you missed it, Red Ball back. Make sure you hit that like button. If you would like to support the channel, please, $ the St. James Show. You can give that way, $ St. James Show. Which other ways can y'all give? They're always scrolling at the bottom. If you really want to support, you'll do it. If, like I said, if you really want to like the thing, you'll like it. Us always asking you. We just ask you, for some of you who don't support monetarily, we just ask you, would you support by hitting a like? That's your reasonable service over here in the virtual sanctuary. All right. We appreciate you. But yeah. For those of you who helped us almost reach our goal, but that's okay. We're good. You guys support all the time. Thank you, Nicole. Thank you, Londa. Thank you, Mary. Thank you, Jazz Harris. And thank you, Wade. I appreciate you guys for helping us reach our goal on tonight and putting some love for the St. James Show in real deal. What's up, Thank you. Thank you so much. Thank you so much. Thank you, Shauna Renee. She's coming on in here. She said, please don't pass me by. We won't pass you by, Shauna Renee. We appreciate you for coming in here late with your good late offering. That's okay. Always on time. May not come when you want him, but he's always on time. I tell you, I appreciate y'all for coming through, but we got to get out of here. Let's see. Happy Friday, everybody. Enjoy your Friday. Do something very productive. I don't know. I'll come back on sometime this week or something. We'll do something. Who knows? We will try to do something around and have a blessed day, everybody.
I need somebody tonight who can give God praise because somehow you survived. Because not only did He keep you from being discovered, not only did He keep you from being discovered, in the text. He'll keep you from being defeated. Y'all still sleep. Find your neighbor and tell your neighbor, I'm not defeated. Y'all don't want to have no church. I said, get out your seat and grab your neighbor's hand. Y'all still didn't do it. I said, grab your neighbor's hand and tell your neighbor, I'm not defeated. Tell your neighbor, what didn't kill me only made me stronger. I need to find somebody who can testify that God's getting ready to take you, your ministry, your church, your family to another level. And I know there's going to be some devils and some demons trying to figure out how did you get to the next level. But make sure you tell them these words. I survived.